Don't talk back, avoid hoodies, make no sudden moves. Those were just a few of the rules my mother had in case I interacted with law enforcement. They were calmly dished out with an acute awareness of the challenges I'd faced encountering police as a young Black man. Avoid online confrontations about race, never reveal your location online, don't post about the police. Those words spoken to me in college was when I first heard fear creep into my mother's voice. I participated in a movement for racial justice at my college in 2016, shedding light on the detrimental effects of discrimination on minority students. Our group was viciously targeted. They spread misinformation about our intentions and whereabouts through a now defunct Twitter account. Their claims grew so outlandish that student campaigners became the targets of online death threats. My mother saw some of these comments, and while she never asked me to abandon the movement, she advised me to adjust my behavior both virtually and in person because my name and face were no longer anonymous. 5 years ago, such concerns might have been seen by some as outlandish, but now, not so much. For we see how easy it is for the violence in the digital realm to migrate to the world of blood, skin, and bone. How quickly parlor posts can become the rallying cry for Capitol Hill insurrectionists. The speed with which insults long directed to our Asian American brothers and sisters on private group chats on social media transform into rage fuel for racist murderers like Robert Aaron Long. In short, technology has brought our democratic order to the brink, and it is our most vulnerable, unfortunately, POCs and the LGBT plus community who have the most to fear from its collapse. My name is Lindsay, a 3L at Duke Law School, current editor-in-chief of the Duke Law Tech Review, and former president of the school's ACS chapter. I'm proud to welcome you to Antitrust, Privacy, Big Tech, and Democracy. I'm pleased to introduce our moderator, Doha Mekki, ACS DC lawyer chapter leader. Doha.
Thank you so much, Andrew, and good afternoon, everyone. I hope all of you have been enjoying the dynamic programming that ACS has offered this week as part of the student convention. As Andrew mentioned, my name is Doha Mekki, and I have the privilege of moderating today's panel. I want to thank ACS for taking up this timely topic. As Andrew alluded to, technology has been a powerful tool to connect folks all around the world to ideas and to each other. Changemakers have leveraged the internet and social media to organize for positive change. Yet, as Andrew notes, in the last 10 years, we've also seen some of the dangers of the unregulated internet. From the spread of misinformation to increased surveillance, a lack of privacy, and tech companies' ability to deplatform even the most powerful among us, big tech plays a significant role in the administration and the vitality of our democracy. And we know that it can both erode and reinforce democratic ideals. In view of these issues, we have a wonderful and dynamic panel that will discuss issues like content moderation and the First Amendment, the role of big tech in democracy, the spread of misinformation and increased surveillance, how the growth of big tech and the absence of its regulation contribute to the foregoing problems, and most importantly, we will discuss how we can engage in creative lawyering to create or enhance new tools to ensure that our laws match up with the reality of how ordinary Americans interact with big tech. With that, I'd like to introduce our dynamic panel. First, Neema Singh Guliani is the head of national security, democracy, and civil rights public policy for the Americas at Twitter. She previously served as legislative counsel for privacy and technology at the American Civil Liberties Union. She holds a BA from Brown and a JD from Harvard Law School. Next up, we have Professor Genevieve Lakier. She is an assistant professor of law at the University of Chicago Law School, where she researches the connections between culture and law, including the cultural history of the First Amendment and the changing role of the state in the regulation of sex. Genevieve holds an AB from Princeton University, a JD from NYU School of Law, and a PhD in anthropology from the University of Chicago. After law school, she clerked for federal judges in the Southern District of New York and the Sixth Circuit Court of Appeals. She is also a member of the ACS Board of Academic Advisors. Ben Wiseman is the director of the Office of Consumer Protection in the Attorney General's Office for the District of Columbia. He has served as lead privacy attorney in his office and he was responsible for monitoring compliance with state and federal privacy and consumer protection laws. He's investigated businesses that fail to protect consumers' personal information, and he educates the public on privacy matters. Before joining the office of the Attorney General for the District of Columbia, Ben served as a law clerk for federal judges in the Eastern District of Pennsylvania and on the Ninth Circuit Court of Appeals. He was also, in a former life, a civil litigator at Covington and Burling, and he holds a BA from Brown and a JD from Georgetown. So with that introduction, let's jump into the questions. So Genevieve, you were first up. When the internet was in its infancy, many posited that a laissez-faire approach to the internet, which is to say, allowing the internet to evolve pursuant to market forces with little or no regulation, would allow the burgeoning digital economy to achieve its full potential. But of course, in recent years, lawyers, advocates, and lawmakers have come to understand the internet as a regulated space. Can you walk us through some of the high points of that evolution?
Yes, happy to do so. I'm happy to be here. Thanks everyone for coming. So I'm going to try and make this quick because there's been a lot of changes happening. And for the students in the room who take the current framework, the current concern about the pernicious role that in particular the social media companies play in democracy for granted, I think it's very hard to remember where we were, say, 20 years ago when the sort of the modern geography of the internet was emerging. So in 1996, when the Congress passed the Telecommunications Act, which was the last major sort of regulatory overhaul of communications media in the country, and it regulated the first major federal bill to regulate the internet as well as cable companies, radio, all forms of media. It was, and this is kind of hard to remember today as well, it was amazingly bipartisan. There was broad agreement that the Telecommunications Act was a good idea by both Republicans and Democrats. And not only is it hard to remember a period where there was broad bipartisan agreement, what is also shocking when viewed from today's lens is that the broad agreement was that the best way to regulate the internet was not to regulate it. In fact, to provide active protection against certain forms of regulation to the new internet companies that were emerging, which was, among others, Google, and then later Twitter and Facebook, later Facebook and Twitter and Amazon. And the idea there was that, well, I guess two things. One, you don't want government control of the internet because you want this to be a free and democratic space where there can be lots of different voices and different approaches. And two, I think this view that the best way of producing both technological innovation, consumer welfare, and a vibrant public sphere, digital public sphere, is by getting the government's grubby hands off and allowing the companies to engage in a kind of flexible regulation in response to and dynamic response to changing technological, social, and political realities. And this was definitely the idea behind Section 230, I guess the famous or infamous Section 230 of the Communication Decency Act, which was part of this larger telecommunications bill. The idea was not that that Section 230, which immunizes social media companies and other platforms from civil liability for the speech that appears in their platform. The idea was not that this would mean that there would be no regulation of the internet, but that the regulation would come from the private companies, that the best actors, the actors who are best positioned to produce reasonable, dynamic, nuanced regulation of the digital public sphere were the private companies themselves, and that they were better than the government. Now, this view, I think, continues to have adherents, which we see when we watch debates about whether Section 230 should be reformed or abolished or how. There are a lot of people, both on the left and on the right, who continue to think that the best way to regulate the internet is to leave it up to the internet companies to do so for themselves. But, you know, in the last 10 years, as Andrew's remarks suggested, there's also increasing skepticism on this view. And this is really the fight about the future of internet regulation we're having right now. And I think there are three developments that have produced this growing skepticism about whether we should just leave it up to the companies. So the first is just the sheer fact of market consolidation. The idea of laissez-faire regulation of the media is that the best way to produce goods, a healthy media public sphere, is through competition in the marketplace. But for there to be healthy competition, you need to have multiple competitors. And what, in fact, the 1996 Telecommunications Act did was it unleashed a wave of mergers and consolidations, in part because it lifted regulatory caps on ownership and otherwise got the government out of the business of controlling the market. And what happens when the government gets out of the business of regulating the market is not beautiful competition across lots of small players, but you often see, especially in media markets, a very, very significant consolidation. And although this took a while to happen when it came to the internet, because it was in 1996, it was still a very new space filled with lots of small players. By the early 2000s, we start to see Google developing very significant concentration in advertising and search. And as everyone knows now, Facebook and Amazon also are similarly really huge companies that enjoy inordinate both economic and we might think cultural and political power. Okay, so market consolidation is really a problem. Two, along with this, you have the development of new technologies of surveillance and targeting. And this is part of the economic logic of the companies. Google develops ways to target ads, to get more information, to scrape information about the people who are doing searches that it then sells to advertisers who can then use that to better and more efficiently target their ads. This is incredibly successful, right? This is I think one of the reasons why Google is the behemoth it is. But it raises all kinds of questions, both about privacy, obviously, right? And in response, we see growing concern that the internet is just a really dangerous place when it comes to privacy. But later, more recently, I think also about polarization. If people are being targeted, if there is this capacity to tailor your internet experience to the particular fact of who you are, we're seeing that people are really operating in a very fractured digital public sphere, and we might worry about the democratic effects of that. And finally, you have of the last 10 or 15 years, the emergence of social media as this really important social phenomenon. And this goes back to what Andrew was saying. You know, what we have seen, and I'm sure the students who are watching this will know way better than me, is both the really productive and amazing capacity of social media to produce all kinds of really interesting and dynamic conversation and expression, right? Barriers to entry in the public sphere have been lowered dramatically over the last 20 years, and there's been a burgeoning of speech. But also along with this, all kinds of harassing, demeaning, and violence-producing speech. And so given this state of affairs, I think there is this view that laissez-faire regulation simply doesn't cut it, because these both vibrant and deadly spaces of public expression are both part of the democratic experiment, but without regulation are also a very serious threat to it. I'll stop there.
Thank you, Genevieve. That was wonderful. So considering we have a lot of law students watching this and maybe some lawyers, I heard 4 buckets of potential legal tools that I think are really important to reinforce. And so the first is Section 230. The second, I heard competition and consolidation, which of course is the province of the antitrust laws. We heard about surveillance and digital privacy, which is a consumer protection issue. And then we also heard about polarization and civic engagement. And this is exactly what we're going to talk about today. So let's take those in stages. Ben, I'm coming to you next. One of the most pronounced ways in which the law, according to some, has been slow to catch up to the realities of the internet is in the dearth of a comprehensive federal digital privacy law. Can you walk us through what frameworks exist to protect digital privacy in the United States? And in so doing, can you describe any cases of interest in which digital platforms or large tech firms have run afoul of consumer protection laws respecting privacy?
Sure, absolutely, be happy to do so. And thank you for having me. So there isn't a federal national privacy law, which is fairly remarkable, but not surprising given the complete inability for groups to work together in Washington right now. There also, surprisingly, isn't even a federal data breach notification bill that would require companies to report when they have a data breach. All 50 states now have such bills. The federal government still has been talking about it for many years, hasn't had a federal data breach notification bill. So what's happened in the absence of federal action on this is you've seen sort of a patchwork of states creating their own privacy bills. And we're actually at a really momentous time right now, because following California's enactment of the CCPA and the regulatory framework that has been set up in California, you have seen states across the country, I believe there's about 12 to 24 states right now, that have legislation pending and that is working its way through the legislators there. We just saw a bill that was passed in Virginia that mirrored some of the protections of CCPA. You've seen, there's a bill in Washington that is currently moving very quickly, and there are bills throughout the country. So I think if we come back a year from now, we will see a very different landscape in terms of privacy from a consumer protection, from a data collection point of view. There are limits to these bills. I mean, these are bills that control entities' use and collection of your data and provide consumers with very important rights about how companies can collect and use your data, your ability to delete data, your ability to engage with these companies. But that only addresses one part of the problem I think we're here to discuss today, which is this broader sort of surveillance concept of these companies. It doesn't necessarily, these bills aren't addressing some of the larger democratic failures of these platforms. And we need to think more creatively about how to do that. But there are some legislative efforts that are focusing on these things. You've seen biometric bills that have popped up in various states. Illinois has a very strong biometric bill, and there's been some great lawsuits. There's a class action lawsuit against Facebook that recently settled. I believe there's a lawsuit against Clearview AI, which if folks aren't aware of, is a facial recognition company, I guess, if you will, that has scraped images of millions of people across the world and then makes them available through a facial recognition software for law enforcement purposes. But so, I think what we will see is, in the absence of the federal government really standing up, you will see states continuing to put forward creative efforts to try to rein in, digital privacy. How those bills work together is going to be incredibly important. I can tell you that as a state attorney general, and we like to refer to ourselves as a state in the District of Columbia, at least for attorney general purposes. We are working and collaborating with our colleagues across the aisle and throughout the country about making sure that, as these bills progress through states, we are making sure that there are consistencies to the extent we can make sure that the bills aren't going to be in conflict with one another to the extent we can. So it's an exciting moment. I think things, many people don't know about these bills that are sort of pending in their own states. Encourage folks to look into them, because we need more people to have an open voice when these bills come before the legislators, so that they are as most consumer protection friendly as possible and not driven by industry desires.
That's fascinating, Ben. For anyone who's currently sitting through or recently took a federal courts class, it obviously raises questions about the potential for preemption. And I think it's anyone's guess what happens if and when privacy laws are passed, and kind of how they interact with the courts. Because the one thing we can be certain of is that even if our leaders put together a comprehensive digital privacy law that the country deserves, it will be litigated, because that is our way.
And I just note on that, and just to be clear, my comments are sort of my opinions and not necessarily the Attorney General's opinions or our offices. But for any privacy bill, the states feel it's very important that is the floor, not the ceiling of protections, because the states really have been ahead of the curve here and are more nimble and flexible in passing legislation. And so there is a concern that a federal bill that sets a ceiling that preempts state law will eventually become outdated again. And also, as a result of the intense lobbying efforts of big tech, won't be as protective as some of the bills you'll see in various states.
That is fascinating. As a citizen or a resident of the District of Columbia, I wish you the very best of luck for myself and for everyone who lives here with us. So one of the things that is most interesting about this sphere is algorithmic content serving. It's a unique facet of the internet, and it's readily observed in the business models of the social media giants. The public, of course, has become increasingly aware of the ways that content serving can be manipulated to promote disinformation around important public issues. Neema, how do you think it's affected American attitudes towards social media? And specifically, how does this affect calls for regulation or no regulation of tech?
Sure. Thanks for having this panel. Thanks for having me. It's really great to be a part of this conversation. There's been a lot of focus on algorithms recently and concern about, the impact that would have on the way social media companies, can affect, consumers and can affect our broader society and democracy. And there hasn't really been a consensus about the full range of that concern, right? There's, I think, some people who believe that some of the algorithms that are used by social media companies may have biases built in, some unsubstantiated concerns that the algorithms are maybe based on things like political ideology instead of other factors. There have been other members of Congress who have raised concerns about algorithms exacerbating discrimination and potentially sort of running afoul of existing civil rights laws. So we've seen, I think, this concern about algorithms, articulated in different ways, but I don't think there's been, amongst Democrats or Republicans, a real consensus around what the core concerns are. I will say, I think this is an area where, algorithms are built in to many of these products and do help to create a positive consumer experience. Think about like the number of tweets a day, right? And the fact that algorithms can help, can be used to help create a better consumer experience by elevating content that is more relevant. So I think the idea that, the solution is to get rid of algorithms isn't really reflective of some of the positive benefits of these tools that have become part of social media companies. But I think the concern that a lot of people have, which is that, these are tools where we have often limited understanding of how they work, and the long-term concern that they might be impacting, I think, broader systems, whether we're talking about misinformation or democracy. So I think, I always try to think of like, what is the solution here, right? And how do we move forward from, the reality where we're in, where we see a lot of positive benefits of technology and social media, the ability to jumpstart movements, the ability of people to, find others like-minded who can start groups like activists and journalists, while mitigating some of the concerns that people have raised that are legitimate. And so I think there's really two concerns that are two solutions that I've seen people gravitate towards, and I think are worth more discussion. One is this idea of how do we give individuals more algorithmic choice, right? And so, when you're using a particular platform, the ability to control, the algorithm that might influence the experience you're having. So at Twitter, for example, there's a sparkle icon. You can, click that icon and have tweets shown chronologically, and sort of instead of based on an algorithm that is designed to surface the content that might be most relevant. So that is an option. I think that's a good start. I think there's more work that we can do on the technological side to enhance the ability of people to sort of choose the algorithms that affect their experience. The other solution, I think that Congress is really in the early stages of thinking through is algorithmic transparency, right? And how do we increase the transparency around the algorithms that are used not just by social media companies, but by a range of businesses, to make sure that we're ensuring that they're designed in a fair and responsible way, and that we're mitigating some of the potential concerns that could come up. I think in this realm, we should also be thinking about like open internet protocols and other tools that make it easier for smaller businesses to address some of the concerns with algorithms, or use maybe commonly tested algorithms, and for the communities writ large to understand and be able to test some of these ideas. And so, I guess if I would leave you with a thought, it's that I think algorithms are here to stay, and I think there are concrete solutions to help address some of the concerns that people have raised. But we're really in the early stages of thinking through the technological mechanisms to put in place these kinds of reforms, and thinking through how we can make sure that they really address the problems people have raised.
Doha, can I jump in? Can I just add a few things?
Sure.
So I guess I just want to emphasize what Neema was just saying about algorithms having this beneficial role and this detrimental role, and about the fact that we are in the early stages. The fact that one of the reasons why maybe it's taking Congress, and I think scholars, policymakers in general, so much time to try and figure out what to do about the problem, which is social media, or maybe more broadly, the problem, which is big tech, is that the problem is to some degree a new one. The problem of private control and anti-competitive behavior of important media channels is not a new one. But the fact is that especially the social media platforms, they're just not like any media we've dealt with before. Up until this point, we are accustomed to, say, the telephone services, which the big, powerful private companies that pose all kinds of challenges, but their primary role is just acting as a conduit of information. And on the other hand, we have the television and the radio broadcasters, and their primary job is producing content. But the social media platforms, they do something else. They're partially like a conduit. They are a platform for other people to speak, but they're also constantly making content choices, algorithmic choices about what content to refer, what content to highlight, how to arrange things on the space. And so they're sort of halfway between traditional sort of legacy media and the telephone or the telegraph companies. And so it requires, I think, really new regulatory solutions and ideas. And just like we might look back at the 1996 Telecommunications Act and say, wow, people really thought that they knew what the future held, and they imposed this kind of laissez-faire vision on the internet when the internet was just getting going and without recognizing the dangers. I do worry that too much regulation or being too committed to our understanding right now of the problems is similarly perhaps worrisome, because this is really a new problem. And so I think the goal should be to have dynamic regulation that allows there to be evolving understandings, evolving regulatory approaches to the problem of social media and to big tech, which is why, just to pick up on Neema's two solutions, I think algorithmic transparency is a really good idea, because one of the things it does is, and generally transparency mandates more broadly, it allows more information about what the platforms are actually doing and how they're doing it to become part of the public conversation, to allow there to be a constant kind of dialogic response to what the platforms are doing, rather than having us just to trust in the black box, which is the algorithm. I'm more skeptical about algorithmic choice because, and this goes to something Ben was saying earlier, regulatory frameworks like our current privacy laws that rely on consumers opting in or opting out or consenting, they sound really good because they're about giving autonomy to the consumer, and you might think, well, it gives people the right to make choices about their own internet experience. Maybe. There's one question about how much people read opt in or opt out, how meaningful these consent choices are. And second, though, it just doesn't take account of the sort of externalities, the third person harms, the sort of structural problems that might be created by people opting in voluntarily because they don't care if their data is collected, or they don't care if Twitter promotes certain content. In fact, they want that. That's why they go to social media. They want to get the bias enhancing, community solidifying content that they like. We know that people really want their biases to be reinforced. And so this is one of the things that's so attractive about social media. But we might really worry about the third party harms. And so although I know the companies right now are really excited about a regulatory solution that's based on algorithmic choice, I think we want to think longer term about what's going to enable there to be dynamic regulation in these companies, so that we can, as we learn more about both the problems and the benefits, we can update our regulatory approach.
Oh, sorry, go ahead.
No, I was just saying, I think Genevieve makes some good points. I want to sort of add one and then maybe talk a little bit more about algorithmic choice. I think, when we're thinking through the regulatory solutions, one of the things I think is most important is that we think of, as Genevieve said, a model that can adapt to new technology, but also one that's not going to entrench the biggest market players, right? One that's going to allow that kind of innovation, it's going to allow smaller businesses to enter the market. And so I think that that's something that we really have to be conscious of. And I think with algorithmic choice, I take Genevieve's point. I do think that there is a lot more work and a lot more thinking we can do. I sort of personally do believe that consumers should have that greater choice over the algorithms that might control their experience. There are some people, for example, that, with millions of tweets a day, the ability to surface what might be relevant to, let's say, a response to a question or particular topic, that improves their consumer experience. And so I worry about a regulatory framework that, in an effort to address some of the problems that have been raised, actually ends up, in some senses breaking or limiting the ability to develop new technologies that actually have positive benefits for someone's life. Think of searching for health information. Think of searching for other relevant information on the internet and trying to surface, surface the information that might be most relevant to an individual.
All of this is fascinating. I think this exchange has highlighted how complex the issues we're discussing are. And a little bit later, we'll talk about some of the potential legal responses to these issues. But another piece that you both sort of touched on is bias, polarization, and I'm really interested in this question of how it affects our relationship to government. So Genevieve, I want to pull you back into the conversation and also include you, Neema. We know that tech platforms can be used to achieve pro-democratic ends. In fact, in foreign countries, we often see notable examples of foreign governments restricting social media access in order to neutralize or otherwise put down popular uprisings. And it raises the question for me, if you are a social media company, is it possible to have different rules for different jurisdictions? And how do we engage the benefits and potential detriments in our choice of regulation, recognizing that these are global products and services, and the way we experience them in the United States might be very different from how they're used in other countries?
So I guess there were two questions there, one about our relationship to government and one about international regulation, which is very difficult, very interesting question when we're thinking about big tech. I mean, on the first hand, I mean, both of those questions are interesting but complicated, because just think about Twitter, for example. So I think Twitter has really changed our relationship to our government, in part because President Trump used Twitter so much, but not only him. He was in some ways just the most famous proponent of an active Twitter presence. I mean, on the one hand, I think it's really allowed much more direct engagement with government officials than previously was the case. I mean, think back to the age-old era of Obama, where Obama took to Twitter sometimes, but it was always, I'm sure it was not him actually tweeting. It was always very sort of nicely put together. But most of the interactions with the public was through press conferences and highly mediated events and through the gatekeepers, which were the journalists. So it was very hard for ordinary people to engage. The social media platforms allow there to be much more direct engagement with government. And I guess I should say that I was on an amicus brief in the Trump case, which was about whether or not Trump, using his Twitter account as part of his sort of presidential account, could mute or block people in his comments. And the argument there, and I think it's a good argument, is that actually, what's amazing about having politicians on these spaces is the ability to respond to them directly, to criticize, to make fun of, to engage in this sort of very egalitarian democratic space. On the other hand, of course, as we all know, it allows there to be all the sort of powerful forces of spin and manipulation used to partisan ends in a very powerful and concrete way. And so I think even while on the one hand, I think it has democratized Americans' access to government in a really profound and interesting way, on the other hand, I think it has really bred a lot of distrust of institutions and only contributed to, because I worry that too much that the blame, that we are blaming only social media for these problems. I think the problems of polarization and loss of faith in institutions go way beyond social media. We should also think about Fox News and other forms of media here and have a much longer history. But certainly social media has only intensified these problems. So on the one hand, we might say it's doing this great democratic thing. On the other hand, it's really helping to undermine a loss of faith in democratic institutions. And I guess I'm just not sure. My crystal ball is not clear enough to know which of these sides of the good side of the happy story, the sad story is going to win out. Is it going to make people, is the presence of social media and what seems like what's going to be a permanent sort of presence of politicians on Twitter and the other social media platforms, now that they see how effective and powerful it can be, is it going to make us a more active and energetic and more engaged democracy, or is it simply going to contribute to the corroding of our democratic institutions? I'm not sure. In terms of the sort of this question about international regulation, I mean, again, there's a happy story there and there's a sad story. So the happy story is that because these are global players, and the US is not the only regulating entity, EU has been very active in trying to think about regulating the digital public sphere. Even if Congress cannot get its act together, there is reason to think that, say, the EU acts to produce, as it has, to try and guarantee more privacy protections, or maybe to provide more due process or transparency mandates. We might think that that could have an extraterritorial effect. And so the fact that these are global players who are being affected by laws in lots of different domains might have a very positive effect. On the other hand, it does raise all kinds of questions about whether laws can or should be exported to other domains. And I think this question about, what's the responsibility and role of the social media platforms in countries which are trying to repress speech, have more repressive speech laws, for example, than our own, whether they should abide by those countries' laws or fight them, and whether that's a sort of democracy promoting act or simply an act of cultural and legal imperialism in some ways, economic imperialism. I think that's a really difficult and complicated question. I'm not going to try and solve it, but I do think when we are thinking about our domestic regulatory issues, we should be thinking about their extraterritorial effect and the effect of other countries' laws on our own.
Neema, do you want to follow up?
Sure, yes. I mean, I'm really glad you asked the question. I think that, as we've been having this domestic conversation over Section 230 and over regulation, one of the things that has been lost is what is going to be the global effect of what the US does, right? There is just a reality that, whatever model the US chooses will definitely affect the model that other countries adopt. And we have to understand how that's going to play out, especially in countries where there may be concerns about free expression, there may be concerns about human rights. It may be that there are really limited ways for individuals to express themselves online, and often, whether it's social media platforms or other internet platforms, those are the ways that individuals are getting their views out there. And often in areas and regimes where they even do so at sometimes great risk to themselves, but in the interest of spurring, progress and in the interest of, advocating for human rights. And so I think that that's something that we very much have to think through. And I think there is a reality that, Section 230, while, it was written decades ago, and, I'm not going to say that every facet of it addresses, the internet and the way it looks today, that it has set a powerful democratic standard and has been, I think, a tool to push back against, efforts in other countries to suppress speech. And I think, just to kind of maybe provide a concrete example, one of the ideas that, some in Congress have proposed is this idea of, notice and takedown, where a government would provide a notice and, a platform would take down a piece of content. And I think that some of those ideas are really complicated when you think about them in practice. They're complicated in the US, even when you think about that. What does that look like? What are the types of things a government order? How would someone have due process to challenge an order? What is the role of social media companies in that mechanism? But we see abroad those same kind of models play out often in concerning ways, where there might be seeking to get content taken down of activists and journalists. Think about India and the recent farmer protests. And so I think particularly when we're in this moment where, you look at human rights organizations like Freedom House and others sort of marking how there have been alarming trends when it comes to internet freedom, we ought to be thinking really strongly about, one, what are we doing domestically and how is that going to affect what others around the world do? But two, investing in international standards and an international kind of mechanism to make sure that whatever regulatory frameworks we're talking about, at the end of the day, they fundamentally are going to protect, freedom of expression, respect basic human rights. And so I do worry about that. I think kind of the other thing Genevieve talked about, and I think you asked about in your question, was kind of the relationship between social media platforms and democracy, right? Good or bad. You've heard people say, is social media eroding democracy? I don't think that the problem we're in right now, when we look at individuals, particularly in the US, who have distrust in political institutions, that's a problem solely due to social media. I sort of agree with Genevieve on this point. I think that this is a much bigger issue about distrust in our institutions. And in fact, you can look at other countries where there is high trust in their institutions. They respect and believe in whether it's a political figure or public health authorities, et cetera, and have not seen that decline, despite the fact that they have access to the internet and despite the fact that they have access to social media platforms. And so I think that when we think about the threats to democracy, whether it's in this country or abroad, that is really a much more complex question. And that has a lot of factors. When we can probably have a whole nother panel about that, right? Whether talking about education or laws or the way that government officials relate to their constituents. I think that is actually a much more complex, larger issue to talk about.
I agree with all of that. One of the most fascinating things to me in hearing this exchange and thinking about others and other spaces, the kind of writing that we're seeing in popular magazines and publications is that everyone seems to have a different conception of exactly what the problem is. And I've thought some about what that means for the regulatory solutions that might be posited as a means of diagnosing the problem, notwithstanding that there's maybe a plurality of views of what the problem is. And so I want to offer one interesting recent event and talk about sort of different views of why it might make us uncomfortable. So I think everyone is aware that former President Donald Trump was kicked off of Twitter. And the deplatforming of Donald Trump, while some saw that as indicative of the power of big tech and an event that made people deeply uncomfortable of the power of tech, others, I think, were happier to see that he was deplatformed. And what I wonder is, would we be less comfortable with deplatforming if, for example, there were multiple social media platforms that he or any other individual could have gone to? And that strikes me as perhaps an antitrust or consumer choice question. So does anyone have thoughts about, one, what that says about the power of big tech and what kind of regulatory solution, if any, might address the concern?
I'm happy to jump in, or Genevieve, I saw you unmute yourself if you want to go. I have a couple of thoughts. I mean, I think the first thing I'll say is, this is obviously a complex issue. It's important to remember the reasoning behind his account being suspended on Twitter, and that was due to the risk and the assessment of the risk of harm, right? And that's something to keep in mind. I do think that this is obviously an important issue, right? There's people often go to Twitter to see what world leaders are thinking about. They go to Twitter to engage, as Genevieve noted, with a lot of those leaders. And so this is something where there's real complexity in balancing this access to information against the potential for harm. And it's one of the reasons that Twitter's re-examining its world leaders policy. We've released a public survey and asked for comments about sort of how world leaders should be treated on the platform, and how to address, I think, this real balance between harm and also access to information. I think to your direct question of would we have felt differently if there were other social media companies out there, there are other social media companies out there, and there were other ways for the president to speak to the public. There were press conferences because he was the president, he had a platform. There were other social media companies, but I think that the long-term point of, in this space, do we want to sort of adopt models that promote more innovation and promote more companies so that people have more choices? I think the answer to that is yes, we do want a regulatory infrastructure that creates an environment where you have a lot of choices, and where if there's concern about one platform because you don't like the way it's structured, you don't find it to be a positive user experience, that you can actually have another option. And so that's, I think, something that has to be a consideration when we're looking at potential legislation or regulations or models to address some of the concerns that have come up.
Can I just add a little bit to that? Which is, Doha, you were saying everyone has their own view of what the problem here is. So I'm going to just suggest one, and this isn't the total problem, but this is one of the problems I think that we're facing, which is, we live in a democracy, and one of the principles of democracy is a certain kind of relative equality. And there's lots of fights about how equal we have to be for democracy to work, but there has to be some basic equality. And worry about government overweening power has been a persistent feature of our setup, our constitutional setup, our regulatory setup. Americans are aware of the threat that government poses to their liberties. But I think similarly, from the beginning, we also have been aware, there's also been a lot of concern about too much private power. companies get too big, both economically big and politically too powerful, it's a real threat to democratic principles. And so I think one of the problems, maybe not the only problem, but certainly one of the problems that we're facing with big tech is its bigness, the sheer amount of political and economic power that the main platforms possess in our current environment. And the deplatforming of the president was really a really amazingly clear indication of the kind of power that the platforms possess. Not to totally take away Trump's voice, because as Neema made clear, like he had lots of other options, but obviously not equally as good, because he really liked the direct engagement of Twitter and the platforms, and they had served him very well. But to alter the conversation in really profound ways and to have all kinds of effects on the way that the political and economic landscape looks. And so that sounds like I'm saying, well, then we just need to break them up and have lots of smaller platforms. But although I definitely think antitrust regulation and enforcement is a good idea in the space, I don't think that is in fact enough, or that we should think that antitrust is sufficient to deal with this problem of corporate power. Because what we've seen in this area and in other media markets is a kind of cartel problem, or I guess we should say coordinated action. And we saw this exactly with the deplatforming. As Neema said, Trump there were lots of social media platforms, but the biggest ones all made the same decision, which was to kick him off. And we see particularly around kind of contentious political questions, platforms often work, maybe not together, but in parallel to make similar kinds of decision making. And so whether you have one Twitter or 4 Twitters or one Facebook or 4 Facebooks, it's not clear to me that would actually solve the problem. I think what you need is regulation to democratize, to constrain to some degree both the economic and the political power that the platforms have. And so I think that means in this space, you need some kind of direct mandate on some kind of restrictions on, or means of making more democratically accountable the content moderation decisions that the platforms make. Now, I don't mean direct censorship. I don't think we have any consensus about what's good speech or bad speech on the platforms. And I would be very worried about the government getting to tell the platforms what speech they can or cannot allow, or at least we're not ready for that yet. But we might think about things like transparency mandates, due process requirements. So I think the deplatforming of Trump was a good idea, because I think his speech was actually inciting violence. And that's a real harm that we should all be aware of, and that one should be deplatformed for. On the other hand, so I think that in that particular instance, it seems like a totally good decision, but I have no confidence, I have no way of knowing whether in the general these decisions are good or bad, or are being used to solve the problems that we would want them as a democratic society to solve. And so I think just the deplatforming should be taken as an indication of the real power that the platforms have, and a real spur to democratic response to that power.
Yeah, just to maybe just focus on one point that Genevieve raised, I completely agree about the procedural due process point. Like when I hear Genevieve say, we're not sure if these decisions are being made fairly or equitably, I think that that's a problem, right? It's a problem for our democracy writ large, and it's a problem for the platforms themselves, who want the people who use the service to trust, because they know if there isn't that trust, they won't use them. They'll go someplace else. And so I think thinking through some of the solutions, when talking about due process and procedural fairness, that really is key. There's been some positive steps here, but obviously more work. Thinking about mandates to require appeals process, better transparency around rules and how those rules are enforced. I mean, we've seen we have a transparency hub that provides aggregate data about how the rules are enforced. Those are good, positive first steps. But I think transparency and due process and procedural fairness are areas where it really makes sense to think through from a regulatory standpoint, because I think it helps address this trust deficit, but it does so without, I think, some of the negative consequences of having the government come in and say, here's what you should have on your platform or not, which is rife with free expression concerns, especially when we think about that applied globally.
And I would just add very briefly to that sort of concept, is this concept of corporate governance. And I think there's an assumption that these entities are very well managed, and that there's someone behind the box that knows everything and could just pulling levers. I don't have that sense or that confidence. And I think these are massive entities, and like any massive entity, there are a lot of things going on that we don't know about, and that these companies don't know about. And one of the benefits of the type of transparency regulations is to build corporate governance within these entities so that they become more aware of actually how their platforms and their systems are working. And so I just wanted to just to jump in and support those type of measures that actually make the platforms better, from the inside, and really do what they should be doing in the first place, which is understanding how their business is working, how the decisions that they make affect people.
Can I add to Ben's excellent point? Because I think, we're speaking to the next generation of progressive leaders. So I think the mandate is to think big. And it is interesting to think about the issue of deplatforming and the problem of big tech as in some ways a problem for corporate law. Like just to think about this as a corporate law problem, not so much a speech regulation problem or also a corporate law problem or an antitrust problem. Because if we think that the platforms are inevitably going to be playing this really important role in running these important sites of democratic discourse, making these decisions, and so we can restrict that to some degree by imposing due process or procedural mandates, which, I think is a really good idea. We might think, though, going back to this question of democracy, we might think that we want to democratize these really important players in the political scene also. So corporate law is structured around a particular notion of corporate democracy, but it's really just shareholder democracy. The shareholders get a vote, but the workers and consumers don't get any say in what's happening. If we think that the platforms are here to stay and that they're going to continue to play this really important role, I just encourage the students in the audience to think in creative ways about how we might want to democratize, not just by regulating from the outside, but by democratizing from the inside. I know that Facebook had an attempt years ago, I think it was in the 2009 or something, which is like light years away, to have users vote on the content moderation policies that the company would enact. And I think it failed because people didn't really vote or they didn't know what they were doing. And there were all these kinds of questions about design. But I do think it's an interesting idea if we think that these corporations are wield so much power. How might one make that power more democratically legitimate? Well, one way is to think about the corporate structure itself.
I think that's a great point. I want to get to public versus private regulation, because Facebook, I think we all know, has an oversight board, and they've attempted to take private control of addressing some of the issues that we've described today through that oversight board. But before we get to that, I'm seeing in the Q&A at least one question about antitrust and some interest from the students about the role of antitrust in this issue. And I don't want to miss an opportunity to address it. When we talked about the deplatforming of the former president, what's interesting about what you said, Genevieve, is the fact that others followed suit, right? So similar ideas were not, hosted on Amazon's cloud service or on Facebook after Twitter made its decision to suspend the former president's Twitter account. And this strikes me as a question about network effects, right? The attractiveness of platforms is based on, at least in part, the number of users you can reach, right? If all of your friends, if your base, if whoever you're trying to talk to is all on one platform, then it says something about the power of that platform and the attractiveness of it for users. And then the other thing you touched on, it really speaks to signaling in oligopolistic markets, right? So there are three big sources of social media products, and they all made more or less the same decision in turn. And we're at a really special time in antitrust enforcement, right? We know that the DOJ has filed a monopolization lawsuit against Google. The Federal Trade Commission has filed a monopolization lawsuit against Facebook. The House Antitrust Subcommittee issued a landmark staff report describing the abuses of the largest tech firms last year. And at least 50 states are involved in either their own actions or have joined the federal antitrust enforcers in legal actions against the tech firms. And we also know that Amy Klobuchar, who chairs the Senate Antitrust Subcommittee, has proposed again, landmark legislation to try to address the power of big tech, among other important economic sectors. And so antitrust I think is viewed by many as a very robust tool for taking on the power of big tech. Ben, I know you have some experience with antitrust and also consumer protection issues. Can you walk us through the pros and cons of relying on antitrust enforcement to discipline the power of big tech?
Sure, and just as a warning, I have very little experience in it, a little experience in antitrust, more in consumer protection. I don't pretend to call myself an antitrust lawyer. I think, the question is, will antitrust law be an effective tool? I think we're about to find out. I mean, I think that you'll see in these lawsuits whether or not antitrust, the laws themselves can be an enforcement tool. What antitrust law does provide, though, which I think is why people generally think it is an effective tool, not because of the laws, which are somewhat outdated, but because the remedies that are available under those laws. The remedies are very broad and wide ranging. You can break up companies, you can wind back transactions. And so those, I think that, my view, the real benefits of antitrust law are those really meaningful remedies that can come out of a lawsuit. Consumer protection, I view very differently, which in some ways is a more flexible and broad legal framework that you can't deceive people, you can't make misrepresentations, you can't act in sort of unfair or abusive ways. Those are all sort of legal terms, but those are much sort of, I guess, simpler concepts and are more liberally applied by courts to find conduct unlawful. But the remedies in consumer protection are probably narrower than those that are available in an antitrust suit. I think a court is likely not going to, in a consumer protection case where a company makes misrepresentations. We have a case against Facebook now regarding the misrepresentations they made in light of Cambridge Analytica. I mean, you see there are creative ways to use consumer protection laws, but the remedies that are available under consumer protection statutes are significantly different than the remedies that are available under the antitrust regime. So all that's to say is, I know we're running out of time. I think we're about to find out. It's an exciting time, and we'll just have to see how these lawsuits proceed, and if not just if antitrust law, but if sort of the court system itself can actually be and law enforcement in general can be a way to try to solve some of these issues.
So I want to answer a really important student question with just the last couple of minutes that we have, because I think it's really important considering the fact that our audience is really comprised of the next generation of progressive legal leaders. The question is, how do law students engage in this work? How someone who's interested in these issues, how do you jump in? If you could each just give some ideas, either based on your experience or things that you might do if you were a 2L or a 3L thinking about these issues, I think that would be greatly appreciated.
Well, I guess I'll give the law professor answer. It's going to be very predictable. But, the first step is to educate yourself, because as I think the last hour has made clear, there's so many different issues on the table and they're so complicated, but they're all so incredibly interesting. But if you're thinking about getting involved, I mean, there are, and this is one of the, I think, the real advantages, because things are so dynamic right now. There's so much activity, but it's happening in the privacy space, consumer protection, antitrust, content moderation. It's happening at the states, it's happening at the federal government, it's happening internationally. So if you're thinking about institutions that you might want to work with or ways to get involved, there's just a wide array of choices. There's the FTC, the FCC, the FEC, there's the EU, there's the civil society, there's the EFF, there's the ACLU, there's the companies, there's the state's attorney general. But before you make those kinds of choices, it's helpful to know what are the different kinds of issues happening in these different domains. So I would just, if you're interested, try and learn a little bit about this. So the privacy questions going on, both government and private surveillance, the content moderation questions, the antitrust questions, the consumer protection questions, the corporate democracy questions. Am I forgetting any? There's so much on the table that it's helpful to have some kind of sense of how you want to get involved, where you want to get involved.
Yeah, I'm a big advocate for the state attorneys general. For those of you who grew up in states where you have strong state AG offices, there are offices all across the country that are looking at this issue, and there are opportunities to work in those offices and be sort of at the forefront of these cases that we've been talking about.
So I would say two things. One, I guess channeling my former ACLUer, take the girl out of the ACLU, can't take the ACLU out of the girl. Go talk to your lawmakers. Talk to not just your congressmen, but your state and local officials, people like Ben, right, who are thinking about these decisions and making them on your behalf. I'm a firm believer that the more people hear from everyday people and the effect, the better our laws and the better our infrastructure will be. So I would say that one. Two, one thing I learned, because I was not, I did not have a technology background, is it's important to understand the technology, right? And think about feasibility. Sometimes our gut reaction is law, regulation, and maybe there's a technological solution. And some of those technological solutions are less fraught than the legal ones that have, I think, larger global impact. So those would be my two pieces of advice. And also, I guess I'll add a third one, think creatively about what you can do. I've bounced around from government to nonprofits to now a technology company. And I think there's important work you can do in each of those places to advocate for good and to have a positive impact. So I would also think creatively about where you sit in that infrastructure and the effect you can have.
These are all great tips. And I would only wrap up by saying that this is a fascinating time to be a lawyer. Thinking about these issues is there are macroeconomic effects, there are microeconomic effects, there are civic engagement, repercussions for how we address these issues. And I feel very strongly that the best time to be a lawyer thinking about these issues is now. And so if you're interested, please don't hesitate to roll up your sleeves or reach out if you have questions. And so while that concludes this program, I want to remind all of the attendees that our next panel discussion, Why to Clerk and How to Land a Clerkship, practical advice from former clerks, will begin at 1:45 p.m. Eastern. Thank you for your attention. Thank you to the wonderful panel for your thoughts and remarks today. It was really my privilege to engage with all of you. And that concludes our program. Thanks everyone.